Okay, so today I wanted to do a longer video on the policy memo that was released by USCIS May 22nd, May 23rd last week. So I've seen a lot of media headlines, a lot of posts stating that adjustment of status is no longer an option. That is not accurate. That is not what the memo says at all. That is a soundbite that is meant to cause fear, and it's doing its job. However, that is not what the memo says. So let's start with the law. The Immigration and Nationality Act, Section 245A, allows certain people to adjust status or obtain their green card in the United States. So again, a policy memo from USCIS does not undo the law that's been in place for 50 years. Let's look at what the memo actually says and who it applies to. So it doesn't apply to those adjusting under 245I, the law from April 30th, 2001. So if you have an old petition and you're adjusting under that, it doesn't apply. It doesn't apply to U visa adjustment of status, special immigrant juvenile status, and a few other categories. So it just applies to 245A, which is the common provision for those married to a U.S. citizen. What the memo actually says is it tries to reframe adjustment of status as an administrative grace and an extraordinary form of relief. Again, adjustment of status in the United States has been a cornerstone of our immigration laws for many, many decades. So again, the reframe and also a focus on discretion. USCIS has always had discretion when deciding applications for green cards for adjustment of status. What we're seeing now is that, yes, they are looking more closely and they are weighing the negative factors more heavily. But discretion means that they're taking the positive and weighing that against the negative and making sure the positive factors outweigh the negative. So we are not recommending that people immediately drop everything and consular process. Consular processing is the process of obtaining a green card outside the US. Why? Why shouldn't everyone just go do that? Well, first of all, the law allows people to adjust status here in the United States. What USCIS is trying to do, if they actually tried to force people to consular process, is illegal. And I believe that a federal court will step in sooner rather than later and put a stop to that. A few other issues with consular processing. So when you submit an application to USCIS, and you have an interview, you are allowed to bring an attorney with you to the interview. That is not true when you consular process. There are no attorneys allowed at the interviews. Second piece is, let's say there's an unfavorable decision with USCIS. While there are limits on appealing discretionary decisions, it is possible to have some review. A motion to reopen, motion to reconsider, other avenues. With the consulate, there is non-reviewability. So basically that means you're stuck with that decision and you're now outside the US without a path, a clear path, if a path at all, to come back to the US. Maybe some people upon leaving the United States may need waivers that they didn't need previously. So again, we are recommending that people evaluate their case, evaluate their options, and not immediately decide to leave the United States. Another issue is that of enforcement. So there are many local USCIS offices spread out across the country. No one knows yet, because it's the first business day after this was released. No one knows exactly how each office will be implementing this memo. The memo, it's guidance and instructs officers how they should handle cases. So with discretion, I mean, we're dealing with humans here. We don't know what their orders are or how exactly they're going to be implementing things. So at this point, we're waiting to see. We will still be moving forward with filing adjustment of status cases with USCIS on a case-by-case basis, like always. We will be reviewing cases thoroughly, and we will be paying attention to discretion and any sort of negative. We'll be discussing that, and clients can decide how they want to move forward. If your case is already pending, this memo shouldn't affect your case. However, we have seen reports of attorneys who were receiving RFEs even prior to this memo being released, but with this memo in mind. So again, we're waiting to see how the implementation is going, and also preparing each case so we can emphasize the positive factors in the case to show that our clients deserve a favorable exercise of discretion. So now is not the time to be submitting applications. If you're not sure or on your own, we definitely recommend that you confer with an immigration attorney prior to submitting anything. Please know the one takeaway from this video is just know that adjustment of status is still an option. You don't have to depart the United States right now. So please get information about your specific case prior to making a decision about moving forward. But adjustment of status as a whole is not off the table. It still exists as a possibility for many immigrants.